Deputy O'Connell.
And thank you for the opportunity to discuss this issue here today. This is with regard to Pat and Ann Keane of Aberdeen Lodge. This case is about two people, two citizens of Ireland, Pat and Ann, and the young family, who are running a modest business, but a couple that were encouraged by the so-called experts some years ago to expand their business. This went wrong for them, as it did for so many people. Their expansion failed, and they ended up carrying losses. Now the problem is that there is the pursuit of a cross-guarantee on their family home and the business that is supporting their two young children. Both Pat and Ann are paying €5,000 a month towards their home and their business, which are one of the same. Myself and Deputy Durkan have written to the bank and their agents and legal representatives, offering to bring about an amicable solution to this, and for both Pat, Ann and their family and the bank. The situation has caused huge strain on this family. We've approached these experts and these agents as two elected members of this House more than a dozen times, and they have failed to meet us on any occasion. These lenders and their agents pepper finance, and it is Goldman Sachs that are pursuing this at the minute. Goldman Sachs have refused to meet with myself and Deputy Durkan, no matter how many times we have asked. This is not what we would expect from a major international lender of much repute. This is, to my mind, a vulture fund coming in to seize an asset that over the last number of years has increased in value by a huge amount. The couple have offered an amount to pay off the outstanding monies on their business and their family home, and this has not been accepted or even explored to any great extent. We are raising it here today because, due to persistent efforts by myself and Deputy Durkan, we have failed to do anything as two elected reps on behalf of two citizens of this country and their two young children, who are essentially going to be on the street if this goes ahead. I'm just going to pass over now to Deputy Durkan so he can continue. Thank you.
Thank you, Deputy. And like Deputy O'Connell, I want to thank you for facilitating this particular debate tonight. This debate is about people taking into account their circumstances at a particular time, taking into account the advice they were given at a particular time, and like a lot of other people during the boom, making a mistake and making a wrong investment and being overloaded, resulting in the major property being repossessed and sold, 20-odd million in value. And the guarantee, which was their family home and their business, and their children's family home and business, is now and has been before the courts and is now liable for repossession, leaving them homeless. If it were an ordinary case, and we fully accept that this matter has been dealt with by the courts, and the courts have, they've gone through the system as it is. There is a belief abroad and at home as well that the lending institutions must get their money back. There's no such thing as risk-free lending. It doesn't happen that way. So the risks that took place and people took during the boom times, that was then, this is now. What I'm saying this evening, Corla, is simply this. We, Deputy O'Connell and myself, have made numerous attempts to reason with the lending institutions involved. We have offered to meet on numerous occasions. It has been rejected on the basis that we would have to put on paper what our proposals were before we met anybody. Now, this is totally unrealistic, as you would well recognise yourself, Corla. The fact of the matter is this: we offered, free of charge, to mediate and to bring about an amicable solution for both the bank and the borrower. This is not something that we did lightly. We offered this in good faith, in the clear knowledge that it can be delivered. And we are now in a position to offer an enhanced settlement, which we will deliver to the lending institutions when we meet them.
Thanks, Count Corla. And at the outset, can I thank both deputies for agreeing to move the topical issue to today. And I want to say at the outset that I'm taking the topical issue on behalf of my colleague, the Minister for Finance, who regrets that he can't take it himself. And at the outset, I want to make it clear that I can't, and I think the two deputies understand that I can't comment in relation to specific matters mentioned in the topical issue, notwithstanding the level of sensitivity that both deputies have articulated very well. The Minister for Finance is aware of media reports relating to a €25 million debt which can be associated with the case. It would be wholly inappropriate for me, then, or the Minister for Finance to comment or interfere in any way on a matter that's before the courts, which from the text of the topical issue appears to be the case. The Dáil will be aware that the Constitution provides for a tripartite separation of powers. The legislator.
My understanding when we accepted this was that the matter was no longer before the courts.
Yeah,
and were it before the courts, it would not have been accepted as a topical issue.
Yeah. Sorry, Count Corley, and the Government is the organ of the State exercising the executive power of the Government, the two Houses of Parliament comprising the Oireachtas and the President and the courts. I will, however, as a result of the topical issue, outline the commitment that the Government has had to assisting in mortgage difficulties. This is demonstrated by the establishment of the state-funded Awalya scheme, which seeks to get solutions in place for those in mortgage arrears by providing them with free, independent expert advice and support tailored to their individual circumstances. This includes the identification and negotiation of solutions and support at court if they are facing repossession proceedings. Awalya has assisted over 11,000 people with vouchers to avail of the free legal aid and financial support since it was established in 2016. The Director of the Insolvency Service of Ireland recently highlighted now that 95% of personal solvency arrangements negotiated by PIPs has resulted in people staying in their own homes. The latest figures for the end of 2018 from the Central Bank of Ireland shows that 111,000 principal dwelling homes mortgages have been restructured. This illustrates how important it is to engage with the lender, because it is clear that it is possible to put solutions in place, notwithstanding the issues that the two deputies have raised, where it obviously seems to be a difficulty engaging with it. While there are still too many in mortgage arrears in the country, we are making progress, and the number of accounts in arrears has been declining every quarter since the peak in 2013. I would like to refer to the practitioners or protections that are in place for those who are in mortgage difficulties. The Government and the Central Bank of Ireland are strongly of the view that the Consumer Protection Regulatory Framework provides strong protections for those in mortgage arrears. The House will recall that late last year the Government supported and indeed assisted by Deputy Michael McGrath in bringing his Consumer Protection Regulation of Credit Servicing Firms Act 2018 into force. The Act has expanded the activity of the credit servicing to include legal ownership of legal title to credit granted under a credit agreement and associated ownership activities. Therefore, if a loan is now transferred, the holder of the legal title to the credit must be authorised by the Central Bank as a credit servicing firm. The Consumer Protection Regulation of Credit Servicing Firms Act 2015 provides that all consumer protections a borrower had prior to the loan sale continue to apply after the loan sale, irrespective of the regulatory status of the new creditor. Furthermore, the Central Bank's Statutory Code of Conduct and Mortgage Arrears applies to the mortgage loan of a borrower which is secured by his or her primary residence, and it sets out how mortgage lenders must treat their borrowers in facing mortgage arrears. Lenders are required to comply with all aspects of the Code of Conduct and Mortgage Arrears, and its protections apply to residential mortgages provide to consumers irrespective of who owns the loan. Non-compliance with the Code is enforceable against regulated entities by the Central Bank of Ireland. The Mortgage to Rent scheme is another government initiative to help homeowners who are at risk of losing their homes, and it is administered by the housing agency who manages the schemes it liaises with. The particulars in relation to the case that the two deputies have raised here this evening, Count Corley, I will bring, and I'm sure that the supplementary points that they've raised, that they will raise, I'll bring to the attention of the Minister for Finance, and I'll ask that the Minister will revert to both deputies directly himself.
Much appreciated. Deputies.
Corla, and thank you, Minister. I mean, the key for me here, and for I assume for Deputy Durkan, is fairness and the humanity of the situation. And the Minister referenced the 25 million debt, but failed to mention what was realised when that asset that was seized was sold and how much of the 25 million was paid off. What I see here is that we have two elected Teachta Dáil, messengers of the people. We have people out there who have asked us to come in on their behalf. We have a vulture fund who I am not the messenger of and don't intend ever to be, who are, to my mind, looking at an asset rather than the debt. And the situation is that this asset has, because of its location, has inflated in value to such an extent. And my concern here is that in a bundle of loans, that this prime asset was picked out specifically as something they wanted to realise the value of.
Thank you. And again, I would say I thank the Minister for his reply, and I have no doubt that he will take it up with his colleague. I would like the Central Bank to become aware of the situation that affects people in these circumstances. I don't agree, incidentally, with the 95% satisfactory settlement in the cases of mortgage arrears all over the country, and I have a considerable amount of experience in dealing with them. So I won't go into that just now, other than to say this. I believe that there is a good case here for the parties involved to make themselves available to resolve the problem. This is not about who wins. This is not about putting people out on the road. This is not about breaking up a family and shoving themselves and their kids out on the road. This is about a commercial loan to which the people are making payments, regular payments, as we speak, and have for the last 2 or 3 years, and are willing to increase and enhance those payments. It is about the lending institution, an internationally reputed lending institution, climbing down off the high horse and dealing with the people as I believe they should deal with the people. And I think if they do that, we can achieve an amicable settlement acceptable to both the lender and the borrower. And we reserve the right to raise this matter in various other fora as well, and we'll do with your help. With your help, McCann Corda, I have no doubt that the matter will be resolved.
Minister.
Thanks, Count Corda. Again, I want to correct the record of the House. The information that was available to me was, Count Corda, from my department officials, was that it was before the courts, but I accept what you're saying entirely. I agree, look, with, that there's an issue here in relation to the Code of Conduct of Mortgage Arrears, not referring to the particular case at hand here, but both deputies will know. I deal myself with, I'm sure every deputy in the House deals with lenders and financial institutions, and the Code of Conduct in relation to those financial institutions, as has been strengthened by Deputy Michael McGrath's Act, puts an onus of responsibility on the lender. And I think it would be important that the lender would engage with customers regardless of the state in which the loan is at. And again, I'm not referring to any specific loan. We all do it as public representatives. We ask the lending agency to accept the bona fides of the people that are constituents of ours. They send in their nominating sheet, they refer to their account, they nominate an Oireachtas member, and the bank or the lending institution, 99 times out of 100 in my own experiences, would accept that. And I think that, notwithstanding, and I'm not referring to any particular case, I think it would be important for every financial institution in the state to accept that when a person X, whether that's Patrick O'Donovan or whoever, sends in a note to a financial institution nominating an Oireachtas member, for argument's sake, Deputy Michael Moynihan, then that the financial institution should accept that and should engage with the Oireachtas member and at least speak to them. I think that's just good manners, and it's in keeping with the Code of Conduct and mortgage arrears. And again, Count Corley, I want to make it very clear that I'm not speaking to any specific loan or any specific mortgage here. But I do think, in 2019, given everything that we've come through, it would be only good manners for a financial institution to engage with my two colleagues. And I would hope that whatever colleague member of the Houses of the Oireachtas has the best interest of a citizen who has drawn down a mortgage, if they seek to nominate somebody to speak to the bank on their behalf, whether that's a personal, the practitioners, the PIPs, whether it is a solicitor, or whether it is just a mere mortal member of the House of the Oireachtas, I would hope and expect that that would be the case.
Thank you very much, Minister. I'm sure the deputies will bring